I think on unfair dismissal, maybe topic 7 like that. Okay, so it can be also um, accepted, but it does not correct. It's not correct for this problem. Okay, unless we mention that your topic for exam is topic number 1 to topic 7. Topic 7 is unfair dismissal. Okay, and the word whether is not correct also. Okay, so I think now you know how to write the issues. So when exercise is given, you must practice. Okay, try again for those who have not practiced. Okay, how to create how to create a issue. Okay, so you can also include like today's topic, so that um, you got more than one issue to answer this very small problematic question where the answer can be up to, let's say, 25 marks. Okay, if it is 25 marks, and I say you must answer within topic 1 to topic number 7. Okay, so you can include so much on this. Okay, you can include domestic, beside duty, domestic inquiry, okay, terms and condition, whether salary should be paid or not, okay, and then whether the dismissal was unfair or not, okay, how is his punishment because he already returned the goods that he took. Okay, there's so many things that you can discuss, even though the question is very in few sentence only. Okay, okay, everyone. Okay, for those who have not tried, please try to write down the issue. Okay. Okay, Zio Ting Tam, can you show us the example answer of this kind of practice? Okay, that's why I asked you to write down the issue. Okay, so once you already write down the issue, it will be easy for me to go on with the activity. Okay, so I already see few already managed to give the issue. Okay, so can you Zio think Tam, can you mention the issue how it should be? Okay, already given few issues above with your friends, the one that I corrected. Can you give your issue? Thing, Tam, is it?
Yes, madam.
Can you just try? Because you have to try. Because if you see sample, but you have not tried, it cannot. Because every question will have different issue. Like for your mid exam, for your what do you call assignment 1, assignment 2 will have a different question. What you have to do is that you try. You try with a simple question whether you can get the issue or not. Can you? For this question, can you get the issue?
Uh, the issue for this, uh, like the previous mentioned one,
Yes, how?
the whether is the duty of the employee.
No, you
No.
must use the person's name. Okay, you
Oh,
Hamid. Hamid name, restaurant Vinda, or maybe Vinda. Okay, you have to like type or you have to write down so that it will be a practice for you. Don't try on the exam day. Okay, now you try to read one case on the issues, on how the issue was stated in that case. Okay, then you try to answer this question. Okay, and see whether you can get it or not. Okay,
okay,
so
madam.
okay, let's say we take one issue. Okay, so whether Hamid has breached the duty of fidelity, let's say that's the issue. Okay, so what is the law for that? Okay, what is the law? Okay, there's no section for that because it's a common law duty. Okay, or you can say it's an implied duty. Okay, so you explain the duty. Okay, saying that the duty to serve the employer faithfully is the duty. Okay, that every employee should have then you can mention, okay, the case that mentioned about the duty. Okay, you put the name of the case, you put the facts of the case, and also the decision of the case. Okay, then you use, okay, after mentioning the case, there's no what do you call section. Okay, you can use the principle. Okay, principle on the duty of employee towards employer. Okay, then you analyze with the fact. Okay, so if you're going to analyze with the fact, you have to take the question here. Okay, where's the analyze part? Okay, analyze. Okay, after you have applied, okay, the law, because the law here is the case. Okay, you have to draw analogy. Okay, the distinction that you make from the case and also the facts from the question that you have. Okay, so you can say that in this case, Ahmed has not been. Ahmed is she's working as a cashier. Okay, so you can say that Ahmed is a cashier. So it's very important for him to be faithfully because he deals with money. Yeah? Okay, the money is the property of his employer, so he must be faithful. Okay, he cannot take any goods from the store without the permission of his employer. Okay, so in this case, okay, he has been unfaithful to his employer. So it's like that. Okay, the how you apply is like that. Okay, so you must take the facts of the question and also the law. You combine. Okay, and then you give your answer. Okay, then you make the conclusion. So your conclusion is very short, saying that Ahmed has been has been unfaithful to his employer. Okay, so if that is the question. Okay, you stop there only because you don't have to go on with dismissal because dismissal is not the topic for the mid exam yet. Okay, so that's how you conclude. Okay, so it's very easy actually. Okay, what is important is that you must know the topic, you must know the law. That means what is the case, what is the section that apply to the particular topic, then you can answer. Okay? Okay, everyone?
Yes, madam.
Is it okay? Okay, okay, now. So for the direct question, it'll be very easy. Direct question means like, here I give you, like elaborate 5 differences between Employment Act and also Industrial Relation Act. So it's very straightforward question. So where you have to use the relevant, you have the introduction, then you use the law. Okay, what is the law in this case? The statute 2 of the statute, if there's any doctrine or principle or cases, you just use that. But in this case, they only ask about differences. Okay, and if they discuss about two cases, okay, 2 cases that decided by the industrial court. So when you are asked to discuss about case or support with case, the case name must be there. Okay, then the facts of the case must be there, and also the decision of the court must be there. Okay, you must not give very brief as in the note. Okay, in your PowerPoint, it's not like that. Okay, any question before we move to today's topic?
Madam, can I ask you?
Yes.
Let's say that if situations have 2 topics, do we have to write both of it at the same time?
2 topics.
Yes, like 2 issues.
Okay.
And then
So you put the issue. Okay, issue 1. Okay, you put the issue here. Where's the issue? Okay, issue. Identify the legal issue. Okay, so it should be in 1 sentence. Okay, you put number 1. Okay, number 1. Whether Ahmed was unfaithful to his employer, or whether Ahmed has breached the duty of fidelity to his employer, Winda. Okay, that's your first issue. Then you put number 2. Okay, whether Ahmed dismissal was unfair or not. Okay, unfair or not. Okay, or whether Winda should pay salary for October. Okay, so you got 3 issue there. 1, 2, 3. Okay, so you go to issue number 1, you use the section, you use the case, you apply and you conclude. Everything complete, then only you move to issue number 2. Okay, and you complete
Okay,
issue
understood.
number 2, then issue number 3. It's like that. Okay, so
Okay,
if you
madam.
are not sure, you can WhatsApp me. Okay, or you put it in the group so that the others also will know. Okay, I mean, can look at the answer and also the mistakes. Okay, for those who of course, you if you want to do practice, you must do it. Okay, you just don't say that I want to do it. I want to do it. Then you do not try. If you try, then you will know. Is it difficult to create the issue or not? Okay. Don't like try on the exam day saying, oh, it's okay. It's like open book. I can refer to my notes. Okay, I can refer to the internet. Don't do that. Okay, because it'll be like 3 hours is not enough then for you, not be enough, because you must learn and also do the practice. Okay, so I think I stop on the problematic question and I move to today's lecture. Okay, any other question? Any other question?
Madam, a question again.
Yeah.
So about the regulation or laws, right? Is everything, all the laws is consist inside the Employment Act, right? We just use the act that inside the Employment Act to write the case, right?
Let's say Employment Act is the provision. Okay, the provision. Okay, the provision, that means the sections. Okay, that today's class you were exposed to more sections. Okay, and also cases, because like you are in the since you are in the what you call undergraduate student, we do not expose you to too many cases, because what do you call just for your knowledge is okay, but it is for the exam, because it's not now is like open book. You can refer to the online you what do you call library. You can get more cases for the assignment, but normally we do not like give you so many cases for your examination, where it is like what do you call, it's a closed book exam. Okay, so Employment Act is only the provisions. Okay, provision means the sections. Okay, cases is different. Cases is where you got from the court. Okay, so it's two different thing. Okay. Can you get
Okay, understood, madam.
understood? Did I answer your question? Or I already went too far?
Yes, I understood.
Okay, somebody was asking me the section when mentioning the rule and law, should we specialize the section in the act? Yes, when you say rule or law, it is the section and also the case. Okay, we need to elaborate the case also. Yeah, you need to elaborate the case for your assignments, because it is like take home, or where you can refer to the internet, any source in front of you, the textbook or internet. If you already like what do you call, update your notes with more cases that you read. Okay, so you can use the cases to answer, because we do not want your answer just from the PowerPoint note. Okay, we don't want like that. Okay, so your answer must be some the kind of answer that is better than our notes. Okay, you don't take everything for the notes and give back to us. We don't want like that. Okay, so because this is like online open book, and you can access to the internet, any textbook. Okay, so we want better something more from the case. So you need to elaborate the case. That means the facts of the case, the decision of the case, and we want the name of the case as citation also. Okay, we don't want you to take some cases from the internet, or somebody wrote on the case, but it's not complete case. So you must make sure that your case is a good case. Okay. Of course, it is in essay. Okay, it's not point form. You cannot write in point form like you when you answer like whether Hamid okay was unfaithful to his employer is a question. But when you want to elaborate with the section, okay, by let's say by referring to section if it is a section from the act, okay, by referring to section 10 of the Employment Act, which provide what you must mention the content of the provision. Okay, then you use the case. Okay, so in A versus B's case, so you must put the name of the case properly. Okay, then you elaborate the case, and then you go to the application. Okay, so it's not like in point form you cannot. Okay, thank you. Okay, so we look at today's lecture. Okay, on terms and condition of employment. Okay, so if you have been employed by a person who is known as an employer, you know the definition of contract of employment and contract of service. You must be employed by another person. Okay, where you agree to serve the person as an employee. Okay, then you will be given the term and condition of employment. Okay, sometimes it's just like one piece of paper, and sometimes you are just informed you are been appointed in appointment letter saying that you are appointed as a assistant what do you call assistant manager. Your salary is 2,000 per month. You must report at 8 a.m. Let's say on 12th of May. Just one piece of paper, but you do not know what are the terms and conditions. Okay, so now we will study the terms and condition of employment. Okay, so your first is that the Employment Act. EA is the Employment Act. Employment Act declares that the employment contract cannot stipulate okay, terms and conditions which are less favorable to the employee. That means your employment contract, okay, must have better terms and conditions. Okay, so now in today's class, we will study about terms and conditions which is in the Employment Act. Okay, and you know the Employment Act have the less or minimum benefit. Okay, so you must know the minimum benefit so that your contract have better terms and condition. Okay, so section 7 says that any terms and condition which is less favorable to the employee than a term and condition prescribed by this act, the Employment Act, and any subsidiary shall be void to that extent. Okay, now I think in the previous class, you have not looked to many sections, and now you're coming to the sections. Okay, so this is how okay you have to use the section to the question. Okay, so any provision which is less favorable, that means it's not good terms, okay, to the employee, then in the Employment Act it is void, and that means it is not valid under the law. Okay, then section 7 okay says that any terms and condition of employment not prescribed by the Employment Act, okay, the employment contract may stipulate such terms and contract. Okay, so because you do not know yet, because this is the beginning of the class, so if there's any terms not stated, okay, in the Employment Act, your employer can have the term. Okay, I can give you an example. Okay, there's no term on study leave. Okay, in the Employment Act, your employer can have this term in your contract of employment. Okay, let's say that every employee after the end of their third year service is entitled to have study leave for 6 months or 1 year. Okay, you can have that term. Okay, because that term is not prescribed in the Employment Act. Okay, so Section 10, I put it together. Section 10 says that the employment contract, okay, must be in writing if it is for piecework or it exceeds 1 month. Okay, piecework means that any project that you're supposed to do for your employer. So your contract with your employer must be in writing. Okay. Then Section 10 says that every written employment contract shall be included setting out the manner in which contract may be terminated by either party in accordance with Part 2. Okay. So sometimes the English is very it is a law. Okay, if you can't understand for those, you can refer to the any textbook in Bahasa Malaysia or the Act in Bahasa Malaysia. This is just for your understanding. Okay, then when you understand, then you can put in your own words to write in English. Okay, so Section 10 says that your employment contract must have, okay, the provision regarding how the contract may be terminated by either party. Okay, normally how do you do if you want to terminate your contract with your employer? Anyone here? Everyone is silent. Bawazir? Hello, students. Can you all hear
Yes,
me?
madam.
Okay, Bawazir Ahmad. Are you
Yes.
there?
Yes, doctor.
Can you give an example how to terminate a contract of employment? What normally do you do? What normally you can do, I mean, to terminate your contract with your employer? Let's say you've been employed during the vacation for 2 months, okay, and you now want to join UUM, okay, what you should do?
First, you have to notify the employer.
Okay, you notify by notice. Okay, so that's how, okay, so this session refer to how you want to notify. So you want to end the contract with the employer, okay, so you must go according to Part 2, or you can have your own way to terminate this by giving notice, okay. The notice period must be at least, the least is according to Part 2, okay. The contract may be terminated by either party in accordance with Part 2 of the Employment Act. So normally by giving notice. Okay, so this one we will study later how the notice should be given. Okay, how many days? Okay, later. Okay, because we got another what do you call another topic on that matter. Okay, then your employment contract also cannot restrict your right regarding trade union activities. Either to join in a trade union activity, that means a registered trade union activities, to participate in the activity, or to associate with any other person, okay, regarding trade union. Okay, the trade union also must be a registered trade union and must be accordance to the Trade Union Act 1949. I think there's the act. I will check this. I think it's not 1949. Okay, anyhow, it must be according to the Trade Union Act in Malaysia. Okay, so if your employer put in the contract of employment saying that you are not allowed to be a member of the trade union, okay, so that provision is void. Okay, so you must remember that because it is against Section 8 of the Employment Act. Okay, so these are the few things, the precondition for your employment contract. Okay, now we look at the definition of terms and condition. Okay, so what do you mean by term and condition? Okay, so according to Palma Sendram Berhad, Palma Berhad and Rockman Employees Union, term and condition is not defined in the Industrial Relation Act. Okay, it's not stated in the Industrial Relation Act, but it is sufficient to say that the terms of employment refers to all matters regarding employment contract. So anything to do the relationship of employer and employee is considered as employment contract. Okay, and another English case says that British Broadcasting Corporation, CORP Corporation, HIMS ORS is others. Okay, this is the short form that we normally use under the law. If there's a few person, okay, let's say me and I got 3 person with me, I want to take case, we put others, we do not put all the name, okay. So in this case, this is an English case. This case says that terms and condition of employment may include not only the contractual term and condition, but those term and condition which are understood, okay, between the employer and employee, applied by the parties in practice. Okay, in practice, that means maybe if you are working in construction industry, banking industry, is very, the terms and condition will be different, or habitually, or by common consent, or without being incorporated into the contract. Okay, so when you say terms and condition, it is not under the Employment Act, it is not under the Industrial Relation Act, but also understood by the parties or used in practice or by common consent, or can be those not stated in the contract also. Okay, so this is the definition of terms and condition.
Madam,
Yes.
for the terms and condition that is not in the contractual, right? Is there any example of it?
Okay. Not in the contract. Okay, so we say that it is understood. Okay, it can be applied by the parties in practice. So, like the Ahmed case. Okay, so in the contract, it's not stated that he should be faithful to his employer. Okay, only the letter of employment will say that he is a cashier. His salary may be 1,200. Okay, and what time he must come to work. Maybe just that. We normally will not say you must be faithful to your employer. You must not steal your employer's property. We do not state that. Okay, so it's understood. It's understood by the parties.
Okay, understood, madam.
Okay, it is like that. Or it is used in common practice. Okay, or maybe let's say if you're working in a construction, so it's applied by the parties that every employee or workman go to the construction site must wear safety helmet. Okay, safety helmet, and also safety boots. Okay, so if the employee do not wear the safety helmet and boots and he got injured, okay, the employer can say that, okay, I already supply but he do not wear, so the liability will reduce. The liability of the employer will reduce because it is applied by the parties in the practice. Every employee who goes to the construction will wear safety helmet and also safety boots. Okay, so this all depends on what kind of industry and also employment you are. Okay. So another explanation. Okay, so term of employment include bonus, wages, rate, hours of work, OT, paid holiday, leave, benefit, grading, promotion, dismissal, retrenchment, procedure, and others. Okay, and I think from the same English case also this one. Okay, condition of employment described as the physical condition under which a workman works, such as pertain to matters of safety, health, and physical comfort. So it's not only about money, pecuniary and non-pecuniary terms, but it also something to do with safety, physical, and also comfort of the employees. Okay, so that's the introduction on terms and condition. Okay. Now we look at the terms and condition. Okay, so terms and condition okay, of employment can be can be expressed and implied. Express means it's written. It's written on the document. It is also sometimes written in the Employment Act. Okay, so implied means something that implied by the parties. It's understood. Is a common practice. Is the customary practice. Okay, so that is implied. No? Express, nyata, implied, tersirat. Okay. So for this, according to Dunson Idura, he already divided like this. Express term can be pecuniary terms and also, all these terms can be pecuniary terms, non-pecuniary, and also pecuniary benefit. Okay, so all these terms can be in pecuniary terms. Okay, pecuniary means money. Okay, non-pecuniary means like leave, rest day, public holiday. You cannot see the money. It's like for the comfort of the employees. Pecuniary benefit also in term of money like maternity leave. Okay, is also maternity allowances is also benefit. Okay, so you can divide. So this is according to one author, Dunson Idura. Okay, so pecuniary terms. So pecuniary terms is like wages, allowances, commission, payment for overtime, insurance coverage. Then non-pecuniary is those cannot be easily quantified in monetary terms, like rest day, annual leave. Okay. Then pecuniary benefit can be maternity benefit, termination layoff benefit, retrenchment benefit, retirement benefit, resignation benefit, and also for the medical benefits. Okay, insurance benefit. Okay, so sometimes like international companies, they put the contract of employment in few pages. It's like in booklet term. Okay, and some companies just give you one piece of paper and say, okay, you can go to the HR department. You can check on your terms and condition. Okay, and the HR department normally have their own terms and condition, which is, sometimes they just let the employee know when there's a problem. Okay, so what happened? Okay, if the employer wants to change the terms and condition. Okay, so the law says that any terms which has been agreed mutually, okay, by both parties, the employer cannot change. Okay, because he is the one who have the prerogative, so he cannot change. Okay, unless he get the permission from the employee. Okay, if he change, then the employee may claim for constructive dismissal. Okay, so actually there's a case for this. If you want, you can find the case. Even I think in the Dunson Idura textbook, there's a case for this. Okay. Okay. So first term is on wages. Wages means salary. Okay, so what we are going to look today is all under the Employment Act. Okay, so wages is basic salary, or you call in bahasa gaji pokok. Okay, and all other payment due under the contract of employment. So any other payment, okay, due to the employee. Okay, but is excluded here bonus, overtime payment, commission, subsistence allowances, travelling allowances is not the wages. Okay, it does not fall under the definition of wages. Because if you want to apply for loan, the bank want to see your pay slip. So this one will not be calculated or included in the amount of your salary. Okay, remember that. Okay, your base only the basic salary. Any other payment can be any other payment, but this is excluded. Okay. So how the employer, should pay your wages or salary under section 18, a contract service shall specify a wage period not exceeding 1 month. That means every 1 month you should be given your salary. Okay, so every month, it depends. It cannot more than 1 month. That means every week, twice a week, 3 weeks once, or 1 month. Okay, for weeks also it be more than 1 month. So it must be within 1 month, not exceeding 1 month. Okay, so if your contract does not specify, so your wage period is 1 month. Okay, remember that. Okay, how your employer can pay? He can pay after he have deducted all lawful deduction. Okay, and he must pay not later than 7 days from the date of the wages. So if the employer want extension, he can ask from the permission from the Director General. Okay. So what are the lawful deduction your employer can make? Anyone here who have working experience? EPF? Okay, yes. So now EPF during COVID is 7%. Previously it was 11. Yesterday, it was announced that employees' EPF was reduced to 7% only. So let's say your salary is 3,000 minus 7%, it will be less 21 ringgit, is it? Or 200? 7%, 210 ringgit will be deducted from your salary. So after graduate, you don't think that if your salary is 3,000, at the end of the month you get 3,000. It's not like that. You'd be reduced for EPF, SOCSO, and other lawful deduction. Okay, remember that. Okay, and the employer will pay you by 7 days. He got the right to pay within the 7 days. So if your salary is until 30th of, let's say, October, if you don't get salary, don't get angry, because the employer have 7 days. Within 7 days, you got right to pay. Okay? And in case termination, being terminated under section 20, wages are payable on the day the contract service is terminated. Okay? So section 21(1), the employer terminates the contract service of an employee without notice, the wages are payable on the day when the contract is terminated. This is where the employer terminates the contract. Okay, sorry, the employer terminates the contract. The employee, okay, must get the salary on the day when the contract service is terminated. Okay, so it's not easy for the employer to terminate the contract unless it is for very serious misconduct. Okay, he can terminate. Okay, so if not, he cannot terminate. Okay, it's nearly 3:41. I want to finish up few slides. Maybe this one. Okay. But if the employee wants to terminate his service without notice, wages are payable not later than the 3rd day when the contract is terminated. Okay. Let's say employee. Okay. Any example that you can use section 21 subsection 2? When you know where to apply, so when you got a question, it'll be very easy. Okay. Anyone want to try? Everyone is very quiet, nah? Siti Aisha, do you want to try section 21, subsection 2, where the employee terminates his service without notice? Are you there? No wonder is it. Hello, students.
Yes, madam.
Yeah, everyone is quiet except for you, I think, and the others only now responding. Everyone saying yes, but no answer yet. How do you apply section 21, subsection 2?
Like someone just leave the job without notifying his employer.
Yes, okay. So if the employee, let's say he got a better job, okay, let's say he got a new job, another job, okay, which is much better, the salary is very good, okay, he got like 1,000 difference, now his salary is 3,000, another employer wants to offer him 4,000, he said, okay, you must join my company immediately next week. Okay, so remember the first section, the earlier section that you learned that you must give notice if you want to terminate the contract with your employer. So you must give notice. So in this case, you are unable to give notice. Okay, so you terminate your service as an employee. You terminate your service without notice. Okay, your current employee will pay you within 3 days. The third day. Not later than the third day. Okay, so you must wait until he pays because you did not give any notice to him. Okay, so that's how section 21 subsection 2 applies. Okay, so maybe I can go to 1 or 2 slides. Okay, so when you get salary, okay, the employer, okay, can give you advances. Okay. At first, it is stated that it is unlawful for him to give advances exceeding 1 month. Normally, advances will be more than that. Okay, so how advances are given to employee because he wants to buy, maybe he wants to purchase a house or land, motor car, motorcycle, computer. How advances are normally given to the employee? Anyone? So how is it? Kanisha Devi, how advances are given to employee? Anyone there? How? Can your no bonus? No. Bonus is something that given free. You cannot ask back. But advances, pendahuluan, you can ask back. The employee must return to the employer. Okay, so it is given in form of loan. Okay, the employer can give, let's say 20,000 to the employee. Employer give 20,000 to the employee to improve his house. So he must make an agreement, a loan agreement with his employer. Okay, this is not the bank. It's between the employer and the employee. Okay, or maybe to purchase land or to buy motor car. Normally motor car, to buy motor car is where companies give advances like 4,000, 5,000 to buy like for the deposit. Sometimes they can even provide loan if very like multinational companies, they provide loan. Sometimes even for the study leave, they can give for the employees to go for further studies. Okay, it depends on which company are you're working. Okay, sponsorship is different. Okay, you do not have to return. This is something that you have to return. Advances must be returned. Okay, it's a loan. It's a loan between employer and employee. Okay, so remember that. Section 22 is about advances given to the employee, where the employee can deduct the salary. Okay, remember that. It's different. It's not a loan. It's not a bonus. Okay. Where can I stop? Let me check. Okay, this is advances. Okay. And section 23 is regarding your attendance in the court. Okay. Attendance in the court means the employee cannot get salary for the time spent in the prison or police custody, traveling to and from the prison, okay, or any other place of custody, or attending or returning from the court, except as a witness to the employer. Okay, so employer do not have to pay any salary if you are being detained by the police, or if you are traveling to and from the prison, okay, or you're going to the court for your own purposes. Okay, remember that. This, for this also, salary can be deducted. Okay, and the employee, okay, can deduct your wages under section 24 for all the circumstances stated here. Okay, so he may deduct your salary. Okay, if you have over payment made by mistake, if you calculated your salary for maybe overtime wrongly, the employer can deduct. For any indemnity that due to the employer also can be deducted, or maybe to recover the advances. You remember the advances that given, okay, earlier, okay, by your employer can be deducted. Okay, any payment for EPF, social security contribution also can be deducted. Okay, so all these can be deducted. Okay, I think it's almost 3:50. Okay, everyone is already getting tired. Okay, I think I will stop here because the other slide is very long. Okay, so we will stop about where deduction can be made. So you can read section 24, subsection 3, and also section 23, and also, sorry, section 24. Okay, it's a bit long how the deduction can be made by your employer. Okay. So any question? So we have to continue this topic for another class. Okay. So any question on terms and condition?
So far, no, madam.
Okay. So I think that's all for the class today. I hope everyone has taken the attendance. Okay. Because I was seeing the attendance is not very full just now, but suddenly it's 60, but no one answering. I think you are not with your laptop or computer. Okay, maybe you have left them. Okay. But if you are listening, it will be advantage for you. Okay, if you are going to read the notes after that, it's not. It's quite difficult for you to understand, because for me to explain it take times, and if you want to read your own, I think it will be it's quite difficult for you also. Okay, so I think that's all. Okay, Intan said that I didn't take the attendance. Why is it? Okay, so I think that's all for the class today. Okay, hopefully we can have the class on Monday. Okay, so thank you, students.
Thank you, madam.
Okay, for those who have not taken the attendance, I'll just share.
Madam, nak
Yes.
tanya. Contoh untuk jawab kes ni, first kali issue, lepas tu bagi undang-undang. Yang application tu apa?
Application ialah you apply. I think it's over the class jadi I can speak bahasa Malaysia to the others. Okay. Aplikasi ataupun pemakaian. How are you going to use section? Okay, katalah ada section kata tadi majikan potong gaji sebab pekerja meminjam buat pinjaman untuk membaiki rumah. Okay. So pekerja tu enggan membayar. Okay. Jadi isu ialah sama ada majikan berhak untuk potong gaji ataupun tidak secara bulanan. Okay. So section yang nak guna tadi ialah section 24 tadi. Okay. Menurut section that's the law. Okay. You dah you
The law kan?
Okay. Menurut section 24 memperuntukkan apa-apa, you must write the contents. Nombor section saja tak cukup. You must write the contents bagi habis semua. Okay, if there's any case, you find the case. Okay, menurut kes ni menerangkan ataupun menurut kes ni you ambil fakta dan juga bincangkan kes tu lah. Okay, habis dah. So you apply. Okay, when you apply, katalah nama tadi nak kata bakal. Okay, bakal majikan mungkin katalah bank. Public bank boleh memotong gaji bulanan Ahmad kerana beliau telah diberi pendahuluan oleh majikan menurut section 24. Itulah yang you apply dengan fakta kes tadi. Fakta soalan tadi you dengan section you bincang di dalam tu lah, bincang-bincang dan what's the conclusion.
Macam tu. Macam kita hujah kita lah.
Kita hujah. That's why it's important for you to read the case. You know how counsel for the kalau case ni kita don't use the word plaintiff and defendant. Kalau employment case been discussed by the court, applicant or claimant, the word used, you can see how the employee argues the case and the counsel for the employer argues the case. So you can.
Lalu tu kita salin balik salin balik ikut dalam buku akta tu lah.
Section tu tak boleh lah sebiji, kalau boleh ringkaskan in your own words lah, itu yang patut dibuat. Kalau final exam close book dulu memang kita minta pelajar bagi ringkasan. Jangan, walaupun akta dibekalkan, jangan copy sebiji. Jangan salin sebiji-sebiji, buang ayat mana yang tak berkenaan, buang semua. Letak kalau ada kalau ada elemen-elemen ke yang perlu dibuktikan di dalam section tu, kena tulis 1, 2, 3 nampak jelas untuk pemeriksa. Jangan bagi pemeriksa pula yang baca satu persatu. Letak semua satu biji, satu section, katalah 5 baris ayat tu bagi pemeriksa baca. Jangan buat macam tu. Put in your own words lah. Sebab tu penting untuk
praktis. Kalau contoh tadi dia bersalah, kalau yang menurut ni dia bersalah contoh.
Kes mana?
Tak, kalau contoh conclusion. Kalau contohnya pasal jenayah, kalau dia dapati bersalah, so dia bersalah lah. Tu dia conclusion macam tu.
Kalau jenayah dia lain, dia bersalah dan tak bersalah kan. Tadi kalau employment, kalau dia tak dibayar gaji, kata berhak mendapat gaji kerana telah bagi conclusion yang nampak bernas lah. Dia kata bersalah tak bersalah, employment tak berapa sesuai lah.
Okay. Terima kasih madam.
Ya. Ada apa siapa-siapa lain ada soalan ke nak tanya? Tak apa. Masih saya tak tutup lagi. Ada? Siapa nak tanya soalan? Berapa orang ni ada? 45 orang ada lagi yang tak leave. Ada? Siapa nak tanya soalan dalam bahasa Malaysia? Tak apa, boleh tanya.
Thank you madam. Tak ada soalan setakat sekarang.
Ya, baik. Any other students yang nak tanya soalan? Tak ada.
Madam.
Okay. Yes. Yeah.